Today I want to share with you a comprehensive framework for kinship advocacy and child protection in British Columbia. A professional analysis of legal pathways, Indigenous sovereignty, and systemic support systems. The shifting paradigm of kinship care and child protection in British Columbia. The landscape of the child welfare in British Columbia is undergoing a profound structural transformation, moving away from historical models of safe, centered foster care toward a paradigm that prioritizes kinship and community-based stability. This shift is rooted in the recognition that children achieve significantly better long-term outcomes, psychological, educational, and social, when they remain within their extended family networks, particularly with grandparents. For grandparents intervening in situations characterized by parental addiction, physical abuse, and verbal violence, the legal system provides a complex but navigatable series of mechanisms designed to prioritize the safety and well-being of the child above all considerations. The professional intervention required to protect the grandchild involves a dual-track strategy. On one track, the grandparent must navigate the private law regime of the Family Law Act, the FLA, which governs guardianship and contact disputes between individuals. On the second track, often necessitated by more acute risks, the grandparent must engage with the public law regime of the Child, Family, and Community Service Act, the CFCSA, where the state, through the Ministry of Children and Family Development, the MCFD, or a delegated Indigenous Child and Family Service Agency, which is the ICFSA, intervenes to protect a child from harm. Understanding the best interest of the child is the central analytical pillar of both regimes. Under the Family Law Act, Section 37 dictates that the court must consider only the best interest of the child, evaluating factors such as the child's health, emotional well-being, the views of the child, the nature of their relationship with significant persons, and any history of family violence. In the context of Aboriginal children, this analysis is further expanded by federal standards introduced by Bill C-92, which mandates the preservation of cultural continuity and the child's connection to their Indigenous language and heritage. Statutory foundations navigating the Family Law Act and the Child, Family, and Community Services Act. The distinction between the FLA and the CFCSA is critical for any legal professional or advocate assisting a grandparent. The FLA is typically used when parents are separating or when a grandparent seeks to establish a legal relationship with the child outside of the ministry's involvement. In contrast, the CFCSA is the primary tool for state intervention and permanent transfers of custody when a child is deemed in need of protection. So we see here on the chart the main feature with the Family Law, Child, Family, and Community Services Act, and then you see all the way down it goes from the primary goal, which is resolve private disputes regarding guardianship and contact, which is under the Family Law Act, and then you move over to the next one, which is the CFCSA, protect children from parental abuse and neglect or harm. So the key standard under the FLA, best interest of the child, and then the CFCSA, best interest of the child. The role of the grandparent must apply for contact or guardianship under the FLA, and then under the Child, Family, Community Service Act, prioritized as kinship caregivers or out-of-care providers. And then there's state involvement, which is in the minimal, restricted to judicial oversight, and then significant involvement of the MCFD, or delegated agencies. And then we move down to guardianship presumption. So guardianship presumption, it shows that parents are automatic guardians. Others must apply. And then moving over to the CFCSA, the focuses on whether parent is able to act as a guardian. So moving down to the Aboriginal specifics, it's general consideration of cultural identity and mandatory priority placement with family, community. Bill C-92. So under the FLA, grandparents are not automatic guardians and must apply to the court, filing a comprehensive affidavit that includes criminal record checks, child protection record checks, and a search of the protection order registry. Being a legal guardian entails the authority to make major decisions regarding the child's residence, education, health care, and cultural upbringing. If the court determines that the parents are unfit, often due to addiction or abuse, the grandchildren or the grandparent may be granted sole or joint guardianship. When a grandparent is only seeking time with the child without decision-making authority, they apply for a contact order. However, courts are notoriously cautious about granting contact orders in high conflict situations. If the punishing parent uses the child as a tool to block contact, the grandparent must demonstrate that the contact is in the child's best interest, despite the hostility of the parent. The jurisprudence indicates that the parental autonomy is respected under the denial of contact, which would cause the child actual or potential harm. Building the evidentiary case, documenting abuse, addiction, and coercive control. Constructing a child protection case requires a systematic collection of admissible evidence that proves a pattern of behavior detrimental to the child's safety. In cases involving addiction, the challenge lies in proving that the substance use directly impairs the parent's ability to provide care. Court looks for red flags such as inconsistent responses regarding substance use history, employment gaps, financial irregularities, or criminal charges like DUIs. Scientific and forensic evidence in addiction cases. To move beyond hearsay, practitioners must utilize objective diagnostic tools. Hair follicle testing is particularly valuable as it provides a 90-day detection window, unlike urinalysis, which may only detect recent use. Continuous alcohol monitoring devices such as Scram or SoberLink can be requested by a grandparent to ensure sobriety during parenting time. So, moving into this box with evidence type, admissibility and utility, documentation strategy, it lists everything relating to hair follicle testing, SoberLink, Scram, text, digital records, expert testimony, school, medical records. So these are things that, again, these are all the details of what grandparents need to compile and keep track of. So, and understanding that you have all these areas that you can relate to for evidence for the judge to make a decision. So documenting physical and verbal abuse. Abuse is often multifaceted, involving physical violence, verbal degradation, and coercive control. Coercive control is a pattern of behavior which may include financial abuse, stalking, and harassment intended to isolate or dominate a family member. Grandparents must document these incidences using a chronological timeline. Description should be factual. Instead of saying a parent was scary, the affidavit should state on October 12th, the parent shouted specific words at the child while standing within 6 inches of their face. Under the best evidence rule, original documents such as photographs of injuries, recorded voicemails, contemporaneous diary entries are prioritized. For verbal abuse, grandparents should save voicemails or record conversations, noting BC's one-party consent laws for legal admissibility, where the parent exhibits abusive behavior. It is also essential to document the child's reaction to these behaviors, such as a social withdrawal, bedwetting, or academic decline, which serves as proof of harm caused. Permanent transfers of custody. The mechanics of sections 54.01 and 54.1. When the MCFD determines that a child cannot safely remain with their parents, the most stable long-term outcome for a grandparent is a permanent transfer of custody. Under the CSA, these sections offer a middle ground between foster care and adoption, allowing the child to remain within the family while granting the grandparent full parental responsibilities. Section 54.01, transfer before a continuing custody order. Section 5401 is utilized when a child is not yet a permanent ward of the state. Typically, the child has been living with the grandparent under a temporary out-of-care agreement or extended family program, the EFP agreement, for at least 6 months. If the ministry determines that the parents are unlikely to recover from their addiction or end the abuse within a reasonable time frame, they may apply to the court to transfer guardianship permanently to the grandparent. Section 54.1, transfer after a continuing custody order. This section is applied when a child is already under the permanent guardianship of the director, a continuing custody order, or CCO. This often occurs when a child has been in foster care or when the parent's rights have already been terminated by the court. Transfer under 54.1 allows the child to exit the state's care and enter a permanent family home. So again, in the box, we're looking at child's status, residency requirements, parental rights, MCFD supervision, succession estate, which is no automatic claim to grandparents' estate unless in a will. And you can read the other ones. Duration, valid until the child turns 19. And again, both of these sections, 54.01 and 54.1, all relate to up to the ages of 19 for the children. These orders provide a sense of physical permanency that is crucial for children recovering from the instability of parental addiction. However, grandparents must be aware that once the order is granted, the ministry's intensive oversight ends and the caregiver assumes full responsibility for the child's needs, often with limited ongoing support. Unless you look at the Indigenous support programs that are in the local organizations for Indigenous people. Indigenous child protection and sovereignty, the impact of Bill C-92. For Aboriginal families in British Columbia, the legal framework is significantly bolstered by the Act respecting First Nations, Inuit, or Métis children, youth, and families. Bill C-92, which came into force in January 2020. This federal legislation addresses the humanitarian crisis of Indigenous overrepresentation in the foster care system, where Indigenous children represent less than 8% of the population, but over 52% of children in care. That is just so awful. That's really disgusting and sad. So the principle of cultural continuity, Bill C-92 introduces cultural continuity, a mandatory consideration in the best interest of the child. The principle recognizes that a child's well-being is inextricably linked to their connection with their family, community, and Indigenous group. For a grandparent fighting a parent who blocks a child from their traditional practices, such as ceremonies, language learning, or time with elders, Bill C-92 provides a powerful legal argument. Cultural erasure is a form of harm that the state has a duty. It has a duty to prevent. Priority of placement, self-government. Under Self-16 of the Act, Section 16 of the Act, the strict hierarchy of this placement must be followed when an Indigenous child is removed from the home. Number one of the child's parents. Two, another adult member of the child's family, specifically grandparents. Number 3, an adult who belongs to the same Indigenous community or people. 4, an adult who belongs to another Indigenous community or people. Number 5, any other adult as a last resort. Furthermore, the Act affirms the inherent right of the self-government, allowing First Nations to develop their own child welfare laws. If a First Nation has enacted its own laws and entered into a coordination agreement that the law has the force of federal law and prevails over provincial statutes in the event of a conflict. This means that for an Aboriginal grandparent, the child's own community may have the legal authority to override the decisions of a punishing parent if those decisions threaten the child's cultural connection. And then again, another info box with provisions of the Bill C-92, impact on grandparents and legal implications. Notice to governing body, the First Nation must be notified of all proceedings. And that's the impact for grandparents, legal implication. Grandparents can seek support from their nation's legal advocates. And then Bill C-92, the right to represent. Impact on the grandparents is Indigenous governing bodies can speak in court. And then the legal implication is the nation can argue for grandparent placement over foster care. So prevention focus, the impact on grandparents prohibits removal due to poverty or housing issues, and the legal implication is emphasizes supporting the family unit rather than apprehension. Care provider status for grandparents recognizes grandparents as caregivers with parental-like rights, and then on legal implications grants grandparents legal standing in protection hearings. Residency flexibility, laws apply regardless of whether the child lives on a reserve, and then protects cultural rights for urban Indigenous families. So case law analysis, precedents in grandparents' access and cultural erasure, understanding how the courts have historically ruled in grandparent-led cases is essential for predicting judicial outcomes. 2 distinct bodies of case law are relevant: those dealing with parental fitness and those dealing with cultural identity. Parental fitness, access, Chapman and Troxel. In the realm of access, now called contact, the case of Troxel versus Granville, 2000 in the U.S. and Chapman versus Chapman, 2001 in Ontario, established that as long as a parent is fit, their decision to deny grandparent access should not be interfered with by the state. However, the analysis changes when fitness is compromised by addiction or abuse. In Smith versus Jones, the court highlighted that there is no automatic presumption that grandparent contact is in the child's best interest. The grandparent bears the burden of proving that the relationship provides a specific benefit that outweighs any parental objection. Cultural identity as a duty of care, Brown versus Canada. The landmark case, Brown versus Canada, Attorney General 2017, addressed the harm caused by the 60s scoop where Indigenous children were removed and placed in non-Indigenous homes. The court ruled that Canada had a common law duty to prevent the loss of Indigenous identity. This precedent is vital for grandparents today. If a parent is blocking a child from their heritage, they are effectively causing a loss of identity, harm that the Brown decision characterizes as devastating and tragic. This establishes a legal basis for a grandparent to intervene, not just for physical safety, but to protect the child's psychological and spiritual well-being. Yes, and I would love to speak that louder. The best interest of the child in the context of conflict. In cases where parents are addicts or abusive, they often engage in gatekeeping or blocking to punish the grandparents who reported them. The court in Chapman noted that forcing a child into contact with a grandparent over a parent's strenuous objection can cause conflict that harms a child. Therefore, a grandparent's case must focus on how they provide a conflict-free sanctuary for the child and how their presence mitigates the trauma the child is suffering at the hands of the parent. Financial support and navigation, empowering the kinship caregiver. One of the most significant challenges for the grandparents in BC is the financial gap between foster care and kinship care. While foster parents receive significant funding, kinship caregivers have historically been expected to rely on their own resources or basic welfare style benefits. However, recent advocacy and policy shifts have improved this landscape. Yes, big celebration on that. Otherwise, foster parents it's a pretty good business, like getting welfare checks and using it for the wrong purposes, which also puts children in a very bad situation with needs that financially are put into drugs and alcohol and other wasteful things, materialistic things. So provincial and federal benefits, you can see here, I'm not going to read them out, but it's a list of child in home of relative now in the provincial province of BC is up to 8,700. Extended family programs, Canada Child Benefits, affordable child care benefits, provincial tuition waiver, Variety BC child grants. So there's a number of programs if you're diligent enough and determined enough to get them or apply for them and really be persistent, because a lot of people just don't want to put the effort in. They don't have to. The fairness for children raised by relatives. Society has been instrumental in lobbying for these benefits. Their work recently led to a win for the CIHR families, ensuring that the annual affordability payment was extended to kinship caregivers. Furthermore, grandparents should be aware of the child in-home relative status, which is grandparented, kept active for those already in the system, even as the ministry moves towards the EFP model. The CPP, Petition and Systematic Change, Kelowna Grandmother Sharing Whiting recently initiated petition E6646 to the House of Commons, advocating for federal changes to the Canada Pension Plan. Currently, CPP child benefits are only available for the children of disabled or deceased contributors. The petition argues that seniors raising grandchildren should receive these same benefits, to offset the financial strain of raising a second generation on a retirement income. Our system is so pathetic, isn't it? That's why it comes down to community and, family network or tribal supports are really excellent in most cases, but still ineffective overall. This effort demonstrates the power of collective action in empowering grandparents. So community resources and advocacy networks, grandparents in British Columbia have access to several high-level advocacy or organizations that provide the village needed to raise grandchild under difficult circumstances. And Parent Support Services Society of BC, PSS, is a primary service provider for kinship caregivers in BC. They offer the kinship care helpline and support circles, Indigenous Child Welfare Group, monthly cross-nation discussion for Indigenous community leaders. And the Circle Support weekly groups where grandparents can share stresses and learn positive parenting skills. These are active throughout Vancouver Island, including Nanaimo Parksville. I'm going to look into those. Fairness for children raised by relatives, F4CRR, a volunteer-run nonprofit that focuses on systematic advocacy. They represent over 13,000 caregivers and focus on ensuring that kinship families receive the same benefits as foster families. They provide workshops, training, and a storytelling platform called A Time to Be Heard. Well, this is new stuff for me, but happy to be sharing those with you as well. If you've made it this far, thank you for listening. So Qualicum First Nation Child Care Center, I know about that. I work with their education community program. Provides Aboriginal Head Start programs and outreach services for families in the Oceanside community. Aboriginal grandparents on the island specialized agencies provide cultural grounded child protection services, which is the Indigenous Pacific Agency. And then there's NIL 2.0 Child and Family Services. Forgive me for not pronouncing your nation's name right. No to all. I'll get schooled somewhere along the line. Serves South Island Coast Salish communities, offering family strengthening programs and delegated child protection services that use traditional definitions of care. And the Vancouver Aboriginal Child and Family Services Society, while focused on Vancouver, they provide a model of partnering with families to provide child-centered plans. Strategic steps for building the child protection case. To build a case that can withstand judicial scrutiny, a grandparent must move through a logical progression of interventions. So step 1, immediate safety and reporting. Step 2, the presentation and protection hearings. Step 3, establishing the affidavit and evidence. Leveraging Bill C-92 for Aboriginal identity. Future of family law in British Columbia, modernization and coercive control. Provincial government is currently in phase 2 of the Family Law Act modernization project. Includes updating the legal definition of family violence to specifically include coercive and controlling behavior. This is a significant boon for grandparents as it validates the psychological and verbal abuse that is often harder to prove than physical violence. Furthermore, the proposed changes emphasize that the views of the child should be considered regardless of age, provided they can be appropriately understood. For grandparents, this means that even a young grandchild's expressed fear of an addicted parent or their desire to be with their grandmother or grandfather can carry significant weight in court. Conclusion, a multidimensional framework for protection. The protection of grandchildren from addicted and abusive parents in British Columbia requires a sophisticated understanding of intersecting legal regimes, financial systems, and advocacy networks. For the grandparents seeking to intervene, the process is as much about proving parental unfitness as it is about demonstrating their own capacity to provide a stable, culturally rich environment. The emergence of Bill C-92 represents a historic turning point for Aboriginal families, providing the legal teeth necessary to fight cultural erasure and ensure that grandchildren remain connected to their traditions despite the dysfunction of their parents. Simultaneously, the growth of organizations like PSS and F4CRR have created a community of empowerment, ensuring that no grandparent has to face the financial or legal system alone. Very encouraging. By meticulously documenting patterns of harm, leveraging scientific evidence of impairment, and utilizing the statutory mechanisms of Section 5401 and 54.1, grandparents can successfully transition from being sidelined observers to being the primary guardians of their grandchildren's future. The professional path forward is one of persistence, evidence-based advocacy, and a deep commitment to the principle that every child deserves a life free from violence, and a connection to their heritage can never be blocked by a punishing parent. And I speak those words very loud and clear and from my heart and being because of my own personal journey. And I send this message out to all of you other grandparents too that have been enduring great challenges in being blocked and separated from your beautiful grandchildren, that in hopes that through all of these wonderful compositions of information that we can be supportive of each other. And my programs on this YouTube site will tie into my drum lifestyle presentations as well on my website, which is vibeup.ca. And so also featured on this YouTube site, Vibe Up Against Child Abuse. This site or this channel will offer you support on a cultural level through drumming, rattle ceremonies, personal teachings of your own ceremonies, and support in whatever financial ways that can't be met by these programs that I have spoken of here and shown you on this document. This was presented to me through research I did on AI. And so there's quite a bit of it here that I didn't find on the other websites when I was looking at the government website. And I have been to court a couple times and spoken to a judge about my own personal family situation. And unfortunately, I didn't have a lawyer that was capable of focusing on even Bill C-92 and focusing on all these other areas. Like I went to AI, I got more information than from a lawyer who charges $350 an hour. But it's all for the right reason, right? It's a tough journey for us grandparents when we don't have access to all the right information. But you can contact me as well, and leave a comment, and I can get back to you as well, because the fundraising program that I'm starting will also bring out other support, financial support for you in your journeys, as well as whatever other advice I can put on my site, and also the well-being, wellness, drumming programs and songs, and teaching you how to make your own uplifting songs and ceremony programs for yourself. Because when you look at our lifestyles and what we do to deal with stress and what we have available to us when it comes to supporting family, we're not all perfect in this journey, but we're here to learn now. And if you've taken this time to follow this presentation I've done, then it means that truly you're sincere and motivated to learn more, and to see, even as myself, just learning all of this recently, not all of it, but like I say, I've been through the court system a few times, and saw that it was very disappointing. But I wasn't thorough enough, and my lawyer wasn't he wasn't up to par as I thought he might be to bring up my Aboriginal grandparents' rights, and he didn't even tell me about C-92. So now that you know about Bill C-92, it is empowering, and it is a requirement that the judges have to acknowledge how important our grandparenting input is and support is. And if you are disconnected from your culture, and that will make a big difference if you move ahead in it. And what I'm going to be doing is offering training on that, as well as teaching you all the different things that you can do to learn, and to even look into going to your doing your research and reconnecting with your community through your band councils, whatever you can do. I have a lot of wonderful connections that I've gone to for support, and I've had a lot of great matriarch teachings in my life that I didn't have in my own northern upbringing when I lived in Prince Rupert. So my village is Laqualams, but I didn't spend much time there, and we've been so outdated in our cultural teachings and upbringings. But through my 48 years, it's been a wonderful journey, a learning journey for me, to get closer to my ancestral teachings and to be able to bring that into my children's lives, and now into my grandchildren. Well, one grandchild's life, she was so into her cultural activities with me, and really got connected to the vibes of our ancestors. And so I know she misses being a part of it, and I look forward to being able to bring her back into that. And someday looking forward to the whole family going through generational healing time. But right now we have to get through these other complicated legal channels, and just being positive about it, supporting each other in prayer, supporting each other, and just putting out, even for you to have compassion for what I spoke of in my own challenges. I send out my compassionate love and friendship vibes to you, and sending the ancestors to, just to also encourage them to be supportive around you, because we are all connected, but there's a little bit of a disconnect and a gap there that we have to keep bringing together vibrationally. So I just say that and finish up our time here, and encourage you to keep getting educated and even look into AI. I use a program that is very powerful, and all AI is becoming so amazingly advanced. I use it for producing videos, but I use Google Gemini program, and there's just a lot of research capabilities in that system, and it has just given me so much support and even putting out this presentation to share with you today. So be strong and vibe up. If you don't have a drum, you can make a drum out of anything. Hum, sing, whatever you can do for empowering yourself just by encouraging yourself that you're an amazing human being, and that you have the desire to protect the innocent, whether it's your grandchildren or your children or somebody else's children or animals or the environment. We have to be unified in that high vibe lifestyle. So I just send a wonderful power thought to you for your strength and for your nurturing of your system, to keep your stress at a low level, because you don't want to waste your good vibrations on being stressed and sad. So you just be excited that there's hope ahead, and we'll all be in this together. So Nithwan, Deutschen Oi, and Siepen Sam Lakaga.